4 years ago, I put this slide up, and I haven't changed the slide since doing these presentations. I've done over 150, 200 presentations on the medical marijuana law statewide, and also nationally too. And really the best way to describe the medical marijuana law, or the Medical Marijuana Act, it truly is a hornet's nest. One thing about the act is there's so many nuances within this act that you definitely do not, no pun intended, you don't want to be stung by this act in any way, shape, or form. And obviously, you'll see that when I go through this PowerPoint presentation, I'm going to give some overview on marijuana, some statistics recently. You have two handouts. One handout is a 20-question quiz, and then the other handout's a little more detailed, a little more thick. And the first part of that handout, it'll say medical marijuana, and it'll be pro.con or pro.con.org's or procon.org's website. That's one of the best websites I have seen on the medical marijuana issue, and also on marijuana statistics. And I can't say enough about that particular website. And then also the second page of that handout we'll talk about is from the Office of National Drug Control Policy. And obviously we know where they stand on this particular issue. What is marijuana? I think it's important to keep in mind that in Michigan, marijuana is spelled with an H. It can also be spelled with a J. J is the Spanish version, H is the Latin version. We have taken the H spelling. It's a psychoactive drug extracted from the plant Cannabis sativa. The herbal form of the drug consists of dried, mature flowers and leaves of the female plant, not the male plants. Actually, the male plant is sold as hemp at Lowe's or Home Depot or whatever. You can actually smell it when you walk into Home Depot or Lowe's, the male plant. That would be the rope you're buying. The residus is known as hashish, and the biological active ingredient, as everybody may know, is THC, or 9-delta-THC. We'll come back to that particular issue because that's a very important issue in our state as we speak right now. National survey use. This is amazing. In 2010, 17.4 million Americans were current users of marijuana, compared to 14.4 million in 2007, a 3 million increase in 3 years. Increased rate of current marijuana use in the population 12 and older from 5.8% in 2007 to 6.9% in 2010. Now this one name that you'll see here, Gil Karakowski, he's a very important person to know. You may want to do some background research on him because of what he says is where the Obama administration stands on the medical marijuana issue. The Obama administration has no intentions, as of today's date, to switch marijuana from a Schedule I drug to any other type of scheduled drug. That's their position. If you've been watching the news closely lately, the feds have actually been very aggressive in going after medical marijuana dispensaries out west. Emerging research reveals potential links between state laws permitting access to smoked marijuana and higher rates of marijuana use. We're one of those 16 states, including the District of Columbia. If you look at the first page of your handout that I asked you to look at, you will see the 16 states, the amount of marijuana that you're allowed in those particular states, and most importantly, if you look at the last column, it says accepts other states' registry ID cards. If you notice for Michigan, there's a yes. We accept other states' registry ID cards, but not all states accept our cards. Like for example, if you look at California, they don't accept our card. So if you go to California with your Michigan medical marijuana card, they will not honor that particular card. I get asked a lot, who's the author behind our particular act? If you go to footnote B, you will see a name there, Karen O'Keefe, JD, Director of State Policies for Marijuana Policy Project. She was the main author behind the writing of our Medical Marijuana Act.
And
yes?
There aren't any more of the handouts that you're referencing, so if they don't have that,
then they should be sharing, then share it. Okay, sounds good. Thanks, Peter. Most common drugs at the Michigan State Police Laboratory. I will say this, drugs are prevalent in our state. If you're not seeing it, you're missing it. You're seeing marijuana, cocaine. What's the alzaprazam? What's the Xanax? What about hydrocone? Vicodin, diazepam? Valium. See, look at the numbers. The percentage is going up at the Michigan State Police Lab. Soma is not a scheduled drug in Michigan. But when it breaks down, it becomes a scheduled drug. Schedule 3. Methadone, oxycodone, codeine. Believe it or not, methamphetamine is way at the bottom here. I mean, when I was in Branch County, methamphetamine, like every file on my desk was a methamphetamine case, but that's not the case with the Michigan State Police Laboratory. Marijuana potency. Average THC in 2008, 10.1%. If you're getting anything less than 5%, you're getting ripped off. 2007, 7.3%. And in 1983, less than 4%. Now, this is a big issue right now with the qualifying patients and the driving issue. And we'll come back to this. A 50% concentration of THC can remain in the body up to 8 days after marijuana use. 8 days after marijuana use. General indicators of marijuana: body tremors, disoriented, relaxed inhibitions, difficulty in dividing attention, dilated pupils, very bloodshot eyes with pronounced veins in the eyeballs. Horizontal gaze nystagmus is not present. When you see those police officers go up to somebody who's under the influence of alcohol and they do this test to look for lack of smooth pursuit in the eyes, that's called the horizontal gaze nystagmus test. That's not present if somebody simply just has THC in their system. Vertical gaze nystagmus is also not present when it comes to somebody who has THC in their system. Now, lack of convergence is present, and I'll go up to this lady here and I'll do the test on her. Ask her to follow my finger. I go around twice. Then I come in. And fortunately for her, her eyes converged. There's no lack of convergence. If one of the eyes would have looped out or button hooked out, then possibly that would be an indicator that that individual may have THC in his or her system. Here's an example of somebody who's on marijuana. Look at the eyelids. He's doing the Romberg test, where you tilt back and count to 30 by yourself. Street price for marijuana, the best website I have seen to determine in your county what the price of weed is going for an ounce is weedprice.com. You may want to write that down, weedprice.com. I literally every night look at websites, blogs, everything for 2 to 3 hours dealing with the medical marijuana issue, not only statewide but nationally. $6 a gram in 1981, $18 a gram in 1991. That was the war on drugs, if you remember, back in the Bush administration, the first one. $10 a gram presently. An ounce ranges from $100 to $400 in the United States, but it's more in the Midwest on average per ounce because we're the only Midwest medical marijuana state. That's it out of the 16 states. Here's some of the things that they do with marijuana. Cocoa Puff is cocaine and marijuana laced together. Frios is marijuana laced with PCP. Fuel is marijuana laced with insecticides. And Geek is crack and marijuana laced together. You can do a lot, obviously, with marijuana to make it even more potent for yourself. Isn't marijuana generally harmless? Research states that chronic marijuana use associated with higher rates of schizophrenia and high doses of the drug can produce acute psychotic reactions. Heavy marijuana users reported that the drug impaired several important measures of health and quality of life, including physical and mental health, cognitive abilities, social life, and career status. Federal law, it's important to keep in mind that the feds are always in the background, regardless of the Medical Marijuana Act. And federal law is pretty clear under the Federal Controlled Substance Act. They classify marijuana as a Schedule I drug, meaning that Congress recognizes no acceptable medical use for it, and its possession is generally prohibited. Michigan court just recently ruled on this issue. The United States District Court ruled that it is indisputable that state medical marijuana laws do not and cannot supersede federal laws that criminalize the possession of marijuana. The feds, in essence, have the ace of spades card. That's the best way to look at it. They trump anything and everything else when it comes to the issue of marijuana. Drug Enforcement Administration's position in June of 2011. This is the website for this entire position paper right here. If you want to write it down, it's 111 pages long. If you want to put it on your nightstand and read it at night, I was able to obviously boil it down to you in 3 bullet points. Marijuana has a high potential for abuse. Marijuana has no currently accepted medical use and treatment in the United States. And marijuana lacks accepted safety for use under medical supervision. This was a determination made after a case that was around for 8 years on this issue. Why is the federal government opposed to medical marijuana? The Food and Drug Administration has concluded that no sound scientific studies have supported medical use of smoked marijuana for treatment. The FDA has determined that the raw material plant, which contains nearly 500 different chemical compounds, has not met the safety and efficacy standards of this process. It's the FDA that's making this determination. According to the Institute of Medicine, smoking marijuana is an unsafe delivery that produces harmful effects. And there's also 3 approved synthetic compounds. Keep in mind, synthetic means chemical. And here are the 3 synthetic chemical compounds. The first one I cannot pronounce, but it's called Dramamine. That's the Marinol. Marinol is actually a Schedule II drug in the United States. And then there's Sesamet, contains the active ingredient navalone, a chemical structure similar to THC. And then this one is a hot one right here, this last one, Savitex. It's in the late stage of a clinical trial. It's from the United Kingdom, and it's a combination of THC and another active ingredient and provides therapeutic benefit without the high from the drug. Obviously, that one is picking up steam. I don't know the company that makes it. Is marijuana addictive? In 2010, approximately 4.5 million people met the American Psychiatric Association Diagnostic and Statistical Manual Disorders diagnostic criteria for marijuana use or dependence. 2010, over 1 million Americans aged 12 or older reported receiving treatment for marijuana use more than any other illicit drug. Initiation of marijuana use, and I think it's important to go through these statistics before I go into the act itself. 2010, approximately 2.4 million Americans 12 or older used marijuana for the first time. This averages out to about 6,600 new marijuana users every day. While recently unchanged from the past few years, the numbers have become higher in the last couple of years. Treatment of marijuana over the last 2 decades, treatment admissions for marijuana have increased significantly. 1992, approximately 93,000 people were admitted to treatment with marijuana as the primary drug for which treatment was needed. You can see the number went 4 times in 2009, estimated at 362,000. Medical marijuana trends in the United States, it started out west, California, Alaska, Oregon, and Washington, came out to the East Coast. Michigan passed the Medical Marijuana Act in 2008. Since then, 3 other states have passed it, including the District of Columbia. Nobody thought it would pass in Arizona. Nobody, except the Arizona citizens. And it passed by 4,500 votes. Very conservative state, and they're going through a lot of troubles out in Arizona. I want to make this clear. The individual who wrote our act also wrote the Vermont Act and the Arizona Act. She seemed to have learned from the issues that were in Michigan and tweaked it with the Arizona Act, because the issues that we are facing, Arizona is not facing as much. 18 states with pending legislation. I think this is important to know that other states, this is really picking up some steam. You can see there are no states down south, but they want to get down south with Alabama. Obviously, West Virginia, and then certainly they want to get around us, Ohio, Illinois, Indiana. So you can see 18 states with pending legislation. It's close to passing in New Hampshire. But Michigan Public Health Code, you'll see the consistency with the Michigan Public Health Code that you see with the DEA's position. Marijuana in Michigan is still, to this day, a Schedule I drug that has not changed despite the Medical Marijuana Act. That means, similar to the DEA's position, finds that the substance has a high potential for abuse. That was DEA's position number 1. Has no accepted medical use and treatment in the United States. DEA's position number 2. And number 3, lacks accepted safety for use and treatment under medical supervision. The ballot proposal language. Why do I put this up there? Because the courts are still focusing on the ballot proposal language. And it's very important to keep in mind to start from the beginning. When you voted on this in 2008, this was right in front of you. How many of us read it? I know I didn't read it. I'll vote whatever way I voted. And this is what it said. Permit physician-approved use of marijuana by registered patients with debilitating medical conditions such as cancer, glaucoma, HIV, AIDS, hepatitis C, MS, and then it says, and other conditions, as may be approved by the Michigan Department of Community Health. Number 2, permit registered individuals to grow limited amounts. It doesn't say unlimited amounts. It says limited amounts of marijuana for qualifying patients in an enclosed, locked facility. Enclosed, locked facility is a hot issue in our state, and I'll come back to that one. It requires the department to set up an identification card system for patients qualified to use marijuana and individuals qualified to grow marijuana. And lastly, this one's a hot issue because it's in our Supreme Court right now, permit registered and unregistered patients and primary caregivers to assert medical reasons for using marijuana as a defense to any prosecution involving marijuana. You, in essence, don't even have to have the card, but if you can meet Section 8 of the Act successfully, then your case shall be dismissed against you, even though you are an unregistered patient. The Act passed in 2008, as everybody knows, and if I had a dime for every time I've been told that 63% voted in favor of it, I'd be very, very wealthy. 63% voted in favor of it. Passed in every county. However, the Act did not take effect, in essence, or the first cards did not go out until April 2009. And when the first cards went out, as you'll see in a second, I want to talk about the application for a second because it's important. There have been some changes just recently. If you go to your handouts, I know not everybody has it, but if you go to page 4, 5, 6, and 7 of your handout, you will have the application in front of you. The application is only 4 pages long. The first page is the instruction page. The second page is what the qualifying patient fills out. The third page is what the physician fills out. And the fourth page is what the primary caregiver fills out if the qualifying patient has designated a primary caregiver on his or her behalf. Still, the fee has not changed. The fee is $100, $25 if receiving SSI, full Medicaid benefits, or SSD. Believe it or not, most choose to pay the $100, even if they're on SSI, Medicaid benefits, or SSD. Why do you think that is? They don't want the feds to know that they're applying for medical marijuana. They don't want to face that issue of getting their benefits cut off. Now look at this. This is the part that has changed. LARA reviews and approves or denies the application within 15 days of receipt. They have 5 days to work with after that. So in essence, what the Act says, Section 9, is that the Act allows for a copy of the application submitted to serve as a valid registry identification card if the card is not issued within 20 days of its submission to LARA. These are the most recent statistics. I just called the department today and said, hey, do you have any recent statistics after January 31st? Because we're now in March. And they said, we don't, Ken. This is the most recent. You have the website page as one of your handout. We have over 220,000 original and renewal applications since April of 2009. We have over 130,000 patients in the state of Michigan. Now, it takes a lot of work, and I'm not trying to be cynical or sarcastic here, so don't take it that way, but it takes a lot of work to get your application denied. You've got to work hard at it. 22,550 people have had it denied. Some of the reasons for denial is you simply paid $90 rather than $100. You didn't pay the entire amount. Also, some denied because depression and high heel pain is not a debilitating medical condition under the Act. All right? I just want you to know that. If you have high heel pain, don't apply for a card. Now, this is the part that has changed. Currently, LARA is working on processing valid and original applications received at the end of August 2011 and renewal applications received for registrations expiring in October, November 2011. As you know, you have to renew your card every year and go through the process. There is a bill pending right now that the renewal process would be every 2 years. We would be the only state that would have it every 2 years. Every other state, and us as of right now, has it every year. What happens after 20 days? Well, obviously these individuals were advised initially to keep a copy of their application, the physician certification form, and a copy of the canceled check or money order front and back with them to prove they submitted an application and LARA did receive the application. They have since taken that language off of their website because some individuals became concerned that they should keep a copy of their canceled check with them. What does this mean? This means this. This is what LARA decided to do on or about February 15, 2012, because there became an issue The problem is 20 days after you submitted that application, or I'm sorry, you submitted your application and the application was deemed to be the registry identification card, unfortunately, the application did not have on it a registry identification card number. And the only thing that police could run through the law enforcement network system was the registry identification card number. So that caused problems, needless to say. So what Lara tried to do to rectify that problem was this. On or about February 15, 2012, the Michigan Medical Marijuana Registry Program is sending out notice of approval letters to qualifying patients and designated caregivers who have yet not received their medical marijuana registry cards. This letter will provide notice that the patient or caregiver registry card has been approved. It's like a temporary, it's like those paper driver's license you get before the real one comes in the mail. It's not like it's still real, even though it's paper, but you know what I'm saying. The letter will, this is what the letter provides. It identifies the person by name, provides their patient or caregiver registry identification card number, which you couldn't have or which was not on the application, which should be verified through a lien query for current status, state the issue date, state the expiration date, and state whether or not the person is allowed to possess marijuana plants. That is probably the biggest part of the card, and we'll come back to that. Confidentiality. This too is important. We have a couple individuals who did not follow this. Only 6 people know who is on this list in terms of applying for medical marijuana cards. Law enforcement, as I mentioned before, these letter of approvals could only check if a registration number was valid through lien. That has now changed because of these approval letters. This is key. When you access the lien, verification through that access of lien can only be given to law enforcement personnel. If it's given to somebody else who's not law enforcement personnel through that access of the lien, under the Medical Marijuana Act, you could potentially be facing a 6-month misdemeanor. It's not a HIPAA violation. HIPAA is federal law. Federal law does not come into play because the feds do not recognize the Medical Marijuana Acts anywhere in the United States. This is what the cards were supposed to look like. We are the only state that does not have what on the cards? Photographs. The only state. I can't answer why that is. It just is. And that's not Zach Morris from Saved by the Bell. Okay? That is a minor's card. There's about 100 minors on medical marijuana as of today's date. I just called and asked, how many medical marijuana patients are minors? They can statistically tell me that information. That's not confidential. Statistics are not confidential. The youngest, as of 3 years ago, still to this date, why he or she is on medical marijuana, I don't know. What the debilitating medical condition, I don't know, but is 5 years of age. When they came out with the cards, here are the cards they came out with. The cards have since changed about a year ago. And I'm thinking when they changed the cards about a year ago, they were going to put pictures on these cards. And they're not. They're hologram and they're laminated. That's a caregiver's card in green. That's the minor's card in orange, and that's the patient's card in blue. Now, if the patient right here, it says authorized to possess plants, no. That tells me most likely the patient has a primary caregiver. And the patient's primary caregiver information will be on the back of the card. There it tells me caregiver, authorized to possess plants, yes. That tells me on the back of that card will be the patient's information. So please keep that in mind. Please also keep in mind a minor can never, ever possess the plants or the marijuana, ever. It either will be the parent or the guardian of that child who's the primary caregiver of that child. I'm not going to talk too much about the qualified patient, but I do want to mention this. It all starts with the doctor. It all starts with the doctor. If the physician approves or issues that written certification, then that person is good to go in order to get that medical marijuana card. Only a physician, an MD, or DO fully licensed in Michigan can make a valid written certification. The physician does not have to live in Michigan. They only have to be licensed in Michigan. The certified physician is not prescribing marijuana a physician cannot do so. You can't get a prescription for a Scheduled I drug. They're not recommending marijuana. The law does not require them to do so. This is what the Act says. The physician is only stating an opinion as to the likelihood of a medical benefit and can do so under law without any legal or professional liability, but certainly they're always subject to malpractice. And the written certification is page 3 of the application. Please keep in mind the written certification is not separate from the application. Here's an example of Find Help Online. We had one of these in Michigan. It didn't go too far, but as you can see, this is a California card, and as you can see, California, they have pictures on their cards. The bottom line, and then I'll get into specifics of some cases here, the bottom line is this. The best way to look at this act, as I constantly tell people, is you're either within the safe harbor provision of this act or you're outside the safe harbor provision of this act. It's either one or the other. And what does that entitle you to if you're within the safe harbor provision of this act? It allows you to possess an amount of marijuana that does not exceed 2.5 ounces of usable marijuana. Notice they go from marijuana to usable marijuana, and I'll talk about that in a second. And allowed to cultivate 12 marijuana plants kept in an enclosed, locked facility. Only the marijuana plants have to be kept in an enclosed, locked facility, not the marijuana. Either, this is also very important, it can't be one or the other. Either the qualifying patient or the primary caregiver can be allowed to possess the marijuana plants. It can't be both. Either or. If she's a qualifying patient, she's designated me to be her primary caregiver and to maintain her plants, she has no access to those plants. I'm the only one that has access to those plants. But she can have 2.5 ounces of usable marijuana on her. At the same time, I can have 2.5 ounces of usable marijuana on me. Here's the safe harbor provision of the law. A qualifying registered patient is protected from arrest, prosecution, or penalty in any manner. Now, this next part I'm going to read to you is not true anymore. This has been somewhat gutted out of the Act based on a case out of Battle Creek. It says, or denied any right or privilege, including but not limited to civil penalty or disciplinary action by a business or occupational or professional licensing board or bureau for the medicinal use or possession of marijuana. In essence, when I read that, that means I can't be fired, terminated, or in essence disciplined for the medicinal use or possession of marijuana. As you'll see in a second, that's not the case here in Michigan. Under the age of 18, as I mentioned, I'm just going to talk about this briefly. Under the age of 18, you need 2 doctors to sign off for you, not 1 doctor. That's written certification from 2 physicians, and the parent or guardian consents in writing. Now, this is also important. We had parents, husband and wife, father and mother, over in Grand Rapids. They both had felonies involving illegal drugs. So neither one of them could be the primary caregiver for their child. So what did they do? They went out and got a limited guardianship for that child so that child could be on medical marijuana. Because it says they have to serve as the qualifying patient's primary caregiver. This is the part that just mind boggles me. They control the acquisition of the marijuana. The dosage, I've never heard of dosage for marijuana, but apparently, I mean, I know if I'm taking 30 Ambien or 1 Ambien a day for the next 30 days, that tells me I take 1 a day, dosage. I don't know how you do dosage for medical marijuana, I just don't. And the frequency of the medical use of marijuana by the qualifying patient. The bottom line is this. The Michigan Medical Marijuana Act does not create any sort of affirmative right under state law to use or possess marijuana. The Act does not repeal any drug law contained in the Public Health Code, and all persons remain subject to them. It only provides a procedure through which seriously ill people using marijuana can be identified and protected from prosecution under state law. This is a very controversial definition under the Act. Medical use. There are still some unresolved issues on this definition. The one unresolved issue that still needs to be resolved is patient-to-patient transfers when it doesn't involve money or sales. remuneration. So if all of you in this room are qualifying patients, and I'm your best friend because I have 150 ounces of usable marijuana, how much am I allowed to have? 2.5 ounces of usable marijuana. So what am I going to do with my overage? I'm going to transfer 2.5 to her, 2.5 to her, 2.5 to Judge Haley, 2.5 to Judge there, 2.5, and 2.5 until I'm down to 2.5. They believe that patient-to-patient transfers are legal based on this definition of medical use. Now, keep in mind, this will be decided here, I believe, in this case out of Berry County that I'll talk about here in a second. But look at this definition. It is overly broad. Medical use doesn't mean medical use, as I think of medical use. It's the acquisition, possession, cultivation, manufacture, use, internal possession, that would be the driving issue, delivery, transfer, patient-to-patient transfers, or transportation or paraphernalia related to the administration of marijuana to treat everybody's basically condition or symptom in this room. Now, when I start reading some of this stuff on the blogs, like I did about a week and a half ago, where somebody says, hey, here's what we can do, or if you go to the one site, I can't think if it's Gregory's site, or not Gregory, the one site where you can buy a bunch of stuff, Craigslist, and they're selling marijuana on Craigslist, it just blows my mind, and it happens to be 2.5 ounces. Now, I'm on Craigslist about a week and a half ago because I want to know what's going on, and so I see this individual who's selling 2.5 ounces of usable marijuana, but what he's doing is he's saying that the 2.5 ounces of usable marijuana is free, but the bong, which comes with the marijuana, is $500. So the patient-to-patient transfer of the marijuana is free, but then the bong's $500. It's like scalping tickets, so to speak. That will be that's obviously an amazing issue. Here's the case out of Berry County that you'll want to know, because we will come back to this case probably in about 6 months to a year from the Michigan Court of Appeals. This particular circuit court judge, she ruled that patient-to-patient transfers, as it appears from the plain meaning of the statute, is covered or protected by the Michigan Medical Marijuana Act. It's People v. Green. This just came out in December of 2011. Marijuana. This is the definition under the Public Health Code. This is not the definition under the Medical Marijuana Act. If you look at this definition, this too has caused some headaches. It means all parts of the plant, cannabis sativa L, growing or not. So it could be a dead plant. The seeds thereof. So if you notice, the seeds are illegal under the Public Health Code's definition of marijuana. But if you look at their definition, usable marijuana. It's not called marijuana. It's called usable marijuana. If you go up to a 9-year-old and say marijuana, they're like, ooh, marijuana, that's bad. Then you go up to a 9-year-old and say usable marijuana. Oh, that's okay, that's good. My dad uses usable marijuana. I mean, it's the play on words, as you can see. Usable marijuana. It's the dry leaves and flowers of the marijuana plant, and any mixture or preparation thereof. That would include the Rice Krispie treats, the brownies, any mixture or preparation thereof, but does not include the seeds, stalk, and the roots of the plant. Notice seeds are not included in their definition. So we have a circuit court judge out of Genesee County who ruled as follows. He directed a verdict prior to it going to the jury that the seeds and stems of 38 ounces of marijuana were not separated in order to show an amount that exceeded 2.5 ounces of usable marijuana. So the case never went to the jury in this particular case. The Genesee County Prosecutor's Office has appealed this decision. Here's another very interesting case. What about the brownies? Do you weigh the entire brownie, or do you weigh what's in the brownie, meaning the marijuana? Well, this judge out of Macomb County basically said this. The term usable mixture, as defined in the Act, includes the aggregate weight of the marijuana and any filler, wherein the only exception is when the filler is a seed, stalk, root, or water. So you're going to weigh the entire brownie according to this judge. Now, I do want to talk about primary caregivers. If you go to page 4 of your handout for the application, this is a very important issue. There's 5 big cases in Michigan that the Michigan Court of Appeals have decided. And I'm going to talk about 5 of those cases here in the next couple of minutes. But I'm going to talk about the first one here dealing with the primary caregiver. If you look at the primary caregiver, it says on page 4, I do hereby declare that I'm willing and able to serve as the primary caregiver for Barbie. I further certify that I'm at least 21 years of age. I've never been convicted of a felony offense involving illegal drugs. Murder, you're good to go. Armed robbery, you're good to go. Criminal sexual conduct, not a problem. Possession of marijuana, 100 of them, so what? You can still be a primary caregiver. There is a bill to try to address that particular issue that's pending right now before the Michigan legislature. And then if you look at bullet number 4, it says I'm a caregiver for no more than 5 patients. Doesn't say 10, doesn't say 50, it says 5 patients. And here's a case that you should know. That's a very important case. People versus Bilesma. To me, this is probably the top 3 of the most important cases. This guy, Bilesma, out of Kent County, had 88 plants. But he only had 2 cards as a primary caregiver for 2 different qualifying patients. So how many plants is he allowed to have? 24. And I wasn't very good at math. That's why I went to law school. So he was only supposed to have 24. So obviously he has more than what he's allowed to have under the law. And here's what the court said. Under the Act, a registered primary caregiver is allowed to possess 12 marijuana plants. For each registered qualifying patient, the primary caregiver is connected through the Michigan Department of Community Health registration process. Because Bilesma possessed marijuana plants that were being grown and cultivated for registered qualifying patients that were not connected to him through the department's registration process, he's now outside this safe harbor provision of the Act, and therefore he's not immune under the Act, and therefore he can be charged for some sort of crime, whether it's manufacturing marijuana or possession of marijuana. If they are within the safe harbor provision of the Act, then they too cannot be subject to arrest, prosecution, or civil penalty. What about the plants? This too is a dilemma for police officers and others around the state. Michigan does not limit the size or distinguish between seedlings and mature producing plants. It could be the little eeny weeny teeny plant or the jack and the beanstalk plant. We don't have any definition for plant under the Act. Here's where they're going with the patient-to-patient transfers. Please do not kid yourself on this issue. According to the Office of National Drug Control Policy, 12 plants can produce quite a bit of marijuana. The annual yield of a 12-plant indoor marijuana grow site would generate between 44 and 72 ounces. So what do you do with that overage? Patient-to-patient transfers. These are some of the issues that some of the prosecutors and some of the police officers are facing, and some of the judges are facing. Is a dead plant a plant? No, officer, you didn't see 30 plants there. You only saw 12 plants. 5 of those plants are dead. You should not be counting those as plants. What about the cuttings? Is that a plant? No, officer, cuttings are not plants. Is a clone a plant? Is a seedling considered a plant if it has a root system? These are some of the issues or some of the dilemmas that we're facing. Obtaining medical marijuana, well, that's the $64,000 question. How do you obtain it legally? Well, you don't. It's a Scheduled I drug. Unlike 6 other states, Michigan is not authorized to regulate growing sites or quality of product under the Act. 6 other states have done that. We're not one of those 6 states. I do want to talk about this very important issue. Enclosed lock facility. This has come up because right now there are 2 Michigan Supreme Court decisions, or 2 Michigan Supreme Court cases that the Michigan Supreme Court will decide. This will be one of the cases that they will decide. Keep in mind, an enclosed lock facility, if the plants are not in an enclosed lock facility, you are now outside the safe harbor provision of the Act, and you can be charged with a crime. That's why the plants have to be in that enclosed lock facility. And this is the way the Act defines it: a closet, room, or other enclosed area equipped with locks. That's the first way. The second way, or other security devices. Is that a guard dog? Is that an alligator? What is a security device? I have no idea because there's no definition for security device. Now this is key, that permit access only by a registered primary caregiver or registered qualifying patient. Now, the Attorney General has come down with 3 opinions. One of the opinions deals with enclosed locked facility. And he has opined that the word "a" there means singular. It means one. So it's either a registered primary caregiver or registered qualifying patient that has access to those plants. It cannot be both. It's singular. This comes up a lot with husband and wives. Husband's a primary caregiver, 60 plants. Wife's a primary caregiver, 60 plants. Now, I know that husband and wife share everything, but they can't share the plants. They can't commingle those plants. They have to put them in separate, enclosed, locked facilities. And here's what the Attorney General said. The Act prohibits the joint cooperative cultivation or sharing of marijuana plants because each patient's plants must be grown and maintained in a separate, enclosed, locked facility that is only accessible to the registered patient or the patient's registered primary caregiver. It cannot be both. This is a very fascinating case. If you look at this case out of Shiawassee County, this is where it started with this enclosed locked facility. Mr. King had a chain link dog kennel behind the house, 6 feet tall, but had an open top and was not anchored to the ground. The marijuana plants were growing inside the defendant's unlocked living room closet. The defendant was charged with 2 counts of manufacturing marijuana because the prosecutor believed that the plants were not in an enclosed, locked facility. Well, the circuit court agreed with the defendant and dismissed the case. But here's what the circuit court said. The circuit court ruled that the defendant was present at the time of the arrival of the police, and he was there at the time the police searched the property. Therefore, the defendant was acting as the security device by limiting access to the marijuana. Now, obviously, that case was appealed to the Michigan Court of Appeals. This is the second big case you should know. Remember I said 5 big cases. Here's the second one. First one I mentioned was the Bilesma case. Here's the King case. This is a very hot topic right now because we just had a guy who was in Detroit. He had plants in his car, and he was delivering those 12 plants to his son, who's a primary caregiver because he's over the age of 18 or over the age of 21. But he was going to school at Central, and he got stopped by the police. He maintained that those plants were in an enclosed, locked facility in the trunk of his car. This is one thing he should have done. He should have read People v. King before he was stopped by the police, because this is what People v. King says, and they're pretty strict on this. They say enclosed area follows the word closet and room, both of which have specific limited meanings and which have the common characteristics of being stationary. Cars move. They're not stationary. Plant inside the trunk of a car, not stationary, not an enclosed, locked facility. Enclosed on all sides. That means this right here. That means some sort of roof or ceiling over it. What about the plants inside the house? Here's what the court said. Trial court's conclusion that defendant acted as a security device for the marijuana growing inside his home is pure sophistry. So I had to look up the word sophistry. And I had no idea what that meant. And when I looked it up, it basically means BS. Okay, that's what it means. And belied by defense counsel's unsurprising admission at oral argument that at times defendant left the property, thus leaving the marijuana without a security device and accessible to someone other than the defendant as the registered patient. This case, oral arguments were heard this past January. I do expect a decision before June as to where People v. King will stand. They're also dealing with another important issue, and that I will talk about a little later, whether Section 8 and Section 4 intertwine in the Act. Is that an enclosed, locked facility? Most likely not. Not closed on all sides, accessible to others besides a primary caregiver or a registered qualifying patient. You can be compensated as a primary caregiver, but you can only receive compensation for cost associated with assisting a registered qualifying patient and the medical use of marijuana. Now, this was in the Act, and obviously this should have been read by certain defendants before they pursued their cases in Circuit Court or the Court of Appeals. It says right there, any such compensation shall not constitute the sale of a controlled substance. You can't sell the controlled substance, even if it's patient-to-patient transfers. That's what the Act says. This is the third biggest case, People versus Redden. There's the majority opinion. This was the first big case that came out back in September 2010. There's the majority opinion, 15 pages long, and then there's the concurring opinion written by Judge Peter D. O'Connell that's 25 pages long. He got more media attention than the majority opinion because he basically went through this Act thoroughly and analyzed this Act as best as he could analyze it back then. And here's one thing that he said. He said that this is the concurrence. Obviously, it's not the rule of law in Michigan. That's why it's a concurrence opinion. The statute does not authorize compensation for the labor, nor does it indicate the primary caregiver may profit financially from the role. The only problem is if I'm a primary caregiver and she's my qualifying patient and I give her 2.5 ounces of usable marijuana and I basically can only receive compensation for cost, and I say to her, you're one of the nicest people I've ever met in my life. I love you dearly. I hope the marijuana is good for you, but by the way, that'll be $4,500 for the cost. How do you know that's reasonable? How do you know that's fair? There's no paperwork on this. There's no way to determine whether that's fair because you don't have to report it to any state agency in terms of the cost that you're getting for assisting somebody in that capacity. I'm going to skip a couple of this stuff, a couple of things because of time. I want to go to custody or visitation. This too is a hot issue. You have a husband-wife, ex-husband, ex-wife, ex-husband and ex-wife, ex-husband, ex-wife. We have 3 children, ages 6, 4, and 2. Me as the ex-husband, I'm a qualifying patient. Therefore, I can use up to 2.5 ounces of usable marijuana. I can also have 12 plants in my house if I've designated nobody to be my primary caregiver. Now, ex-wife finds out that I'm smoking in front of the children. So what is ex-wife going to do? She's most likely going to call one of 3 individuals. Her divorce attorney, the court, well, actually 4, the police officers, and CPS. Probably not in that order, but most likely those are the 4 that will be called. And this is the test that's used under the Medical Marijuana Act. This is not the test that's used in probate court. In probate court, the test is the best interest of the child test. Their test is different, as you can see right here. It says a person shall not be denied custody or visitation of a minor for acting in accordance with this act unless the person's behavior is such that it creates an unreasonable danger to the minor that can be clearly articulated and substantiated. So smoking once in front of my child, is that unreasonably dangerous? Smoking 3 times, 5 times? When does it get to that level? That's the key. Now you'll see in a second, obviously there seems to be a conflict with those 2 laws. Unreasonably dangerous, best interest of the child. Conflict with the law. You'll see in a second that will in the future be an issue where a probate court judge will have to make this decision as to which act supersedes the other act. And obviously we'll have to decide, and I'll show you why here in a second, because of Section 7E of the Act. What I am starting to see is some of this on the websites. These are from attorneys advising their clients that are medical marijuana patients. Treat it like other medicines and keep it out of the reach of their children. That makes sense. If cooking, clearly label any resultant food products as medicinal and store them in a safe place out of the reach of children. That makes sense. Use discretion when medicating and avoid doing so when children are present. Makes sense. And never operate a motor vehicle after medicating. That too makes sense. Insurance, you can't get insurance coverage despite a number of calls where people have asked their insurance company, can I get insurance coverage for the use of medical marijuana? The Act clearly says that you cannot be insured either by a commercial or non-profit health insurer. Now, I do want to talk about a very important issue. What is prohibited under the Act? This is everything that's prohibited under the Act. Number 4 is the key one. Number 4 is the one I really want to talk about. It says operating, navigating, or being in actual physical control of any motor vehicle, aircraft, or motorboat while under the influence of marijuana. Notice the threshold there is under the influence of marijuana. I do want to mention, though, it says any use or possession on the grounds of any preschool, primary, or secondary school. Remember, a minor can be on medical marijuana. But does that mean he or she now cannot go to school because they use or possess it on the grounds of any preschool, primary, or secondary school? That issue, too, will be one that will have to be addressed. MSU has banned it on their campus. I just want to mention that. So, any use or possession in any correctional facilities, the last one. Does that include a jail? Excuse me. Here's to me, this is the most important section of the Act, to me. It reads that all other acts and parts of acts inconsistent with my Act do not apply to the medical use of marijuana as provided by my Act. So if you have a law that is inconsistent with my law, under Section 70 of my law trumps your law. That's what this says right there, Section 7E. Obviously, that comes into play with this. Although the Act prohibits the operation of any motor vehicle while under the influence of marijuana, it does not make reference to Michigan's operating under the influence of drug per se law. We are a OUID per se state. We are one of 16 states that is. That means for prosecution and police, this. If it's a Scheduled I drug or cocaine, there's two elements that need to be shown. They're operating, and they have that Scheduled I drug or cocaine, which is a Scheduled II drug, in your system. Marijuana is a Scheduled I drug. So under the OUID per se law, if you have THC in your system, two elements need to be shown. You're operating, and you have that THC in your system. But if you remember correctly, they take it up a notch. They say, no, no, no. When it comes to qualifying patients, and a police officer stops a qualifying patient, you need to show, in essence, they're under the influence of marijuana. That's another element. They're in a different category than the rest of us. Does everybody see that? It's a very hot, important topic. Because how many people are on medical marijuana? Over 130,000 people. So in essence, if you're taking medical marijuana every day, you'll have that THC in your system. So what should you not be doing? Driving. Here's a case that's a very important case. You'll want to write this down. This is out of Grand Traverse County, Judge Haley's county. We were talking about this earlier. This is a judge who basically said this. The Medical Marijuana Act, he should have said trumps the OUID per se law, but he used the word supersedes the OUID per se law and states that qualified patients are prescribed from operating a motor vehicle while under the influence of marijuana. Therefore, evidence of impairment is a necessary requirement, officers, when you stop somebody who's a qualifying patient. The OUID per se law takes a back seat to the medical marijuana law. There's a case I just want to mention. This case is in the Michigan Court of Appeals. I expect a decision any day now on this particular issue. Now, one of the three judges that's on the Michigan Court of Appeals that's hearing this case, he would have immediately reversed this decision. But he needed somebody else to also immediately reverse this decision when they decided to take this case. There was oral arguments back on February of 2011, and 2012, excuse me. As I mentioned, I expect a decision any day now, and it obviously will make big news. Here's a case out of Delta County. This judge did not buy the qualifying patient argument. He basically said that the OUID per se law was not amended after the adoption of the Medical Marijuana Act to carve out an exception for the medical marijuana qualified patients to drive with THC in their system. Why should they be treated differently than everybody else, is what he's saying. One thing to keep in mind in Michigan, you have to have THC in your system. That is a Scheduled I drug. TCOOH, which is the metabolite of marijuana, or 11-carboxy-THC, according to this court, People versus Fiesel, is not a Schedule I drug in Michigan. I do want to mention that drug driving is a growing problem. I can't emphasize that enough. According to the Fatality Analysis Reporting System, only 1 in 3 of all drivers with known drug test results who were killed in motor vehicle crashes in 2009 tested positive for drugs, illegal substance as well as medication. This is, once again, Gil Karakowski. Drug driving is a much bigger public health threat than most people realize. Here's an example. You don't need the volume. You just watch the driver. Schedule I drug. Now, obviously, that guy should not be driving. And I certainly don't want any of you out on the highway, or I don't want to be out on the highway with my son when he's out there. He broke both of his ankles there. He didn't even realize that he broke them. He's on, obviously, ecstasy, GHB, a combination of both. And that, obviously, as you could clearly see, relaxes his muscles. I do want to emphasize this, the Michigan drug driving issue. Alcohol-related incidents have gone down. Drug-related incidents have gone up. Here's an example. Alcohol-related crashes from the Office of Highway Safety Planning. You can see the numbers have gone down. The .08 law seems to be working. Now, I can't lobby because that is not allowed under what I do, but I just want to remind everybody that there is a sunset clause in the law that if not canceled in the law or rescinded under the drunk driving statute, we go back to a .10 state in 2013, October. Just want to mention that. So if you happen to see your legislature or whatever, I can't lobby again, but I'm just telling you that's where we're at. But you can see it seems to be working. Here's drug-related crashes. You can see the numbers have gone up. And sadly, when it comes out with 2011 statistics here in the next month or so, I expect that number to go up again. Now, what about cannabis-related crashes? Those are cannabis-related crashes. You can see it leveled off 2008, 2009, and then it went up in 2010 to 88. That just deals with marijuana-related crashes, cannabis. I just want to talk about a couple other things. You may start seeing more drug driving campaigns. I think it's an important issue. Here's a drug driving campaign out of Colorado. This is one of the best websites I've seen to detect different types of drugs, drugs.com. Having trouble identifying your pills or medication, you may want to take a look at this site. Unfortunately, because of time, I'm going to skip this affirmative defense. Here's an example, federal agent, jail's doctor. This doctor had 1,870 medical marijuana certificates that she issued between a certain period of time, charged $200 to $150 for renewals. And here's a clinic right not too far from us in Meridian Township. The Department of Justice, if I knew, is anybody here from the federal government? If I knew where the feds stood on this issue, I'd be, once again, a very smart guy. I have no idea where the feds stand. I now know where they stand in the sense that they're going after marijuana dispensaries somewhat aggressively, but they really confused us with this position back in October 2009. They came out with federal prosecutors will be told it's not a good use of their time to arrest people who use or provide medical marijuana in strict compliance with state law. So even if you're violating federal law, as long as you're in compliance with the state medical marijuana law, we won't go after you. And then unfortunately, they came out with this position in June of 2011 and said this: we really didn't mean what we said back in October 2009. Here's what we meant to say. It was never intended to shield such activities from federal enforcement action and prosecution, even where those activities purport to comply with state law. Well, no, actually, that is what you said. So I'm somewhat confused as to where they're at. They seem to be taking an aggressive stance right now. I do want to mention briefly, alcohol, drug, firearms, open letter. This was sent to all individuals who sell guns, to individuals who want to buy guns. This is a fascinating letter. You have a copy of this in your handouts. It basically says any person who uses or is addicted to marijuana, regardless of whether his or her state has passed legislation authorizing marijuana use for medicinal purposes, is an unlawful user of or addicted to a controlled substance, is prohibited by federal law from possessing firearms or ammunition. The bottom line is I asked the department, I asked LARA, the Department of Community Health, hey, did you see, like after this letter came out, did you get a number of calls saying, hey, keep my application, I don't want the medical marijuana? And they did. They actually did. A lot of people decided, I want my gun rather than the medical marijuana. I do want to talk about one issue. First of all, state of Michigan versus McQueen is the big case, big landmark case in Michigan out of Isabella County. It basically held that patient-to-patient transfers, when it involves sales, are illegal. It also held that dispensaries are illegal. The act does not expressly authorize medical marijuana dispensaries. Huge case. What's fascinating about this case is the Michigan Court of Appeals decided this case. This case, the defendants, McQueen, asked that the case be heard by the Michigan Supreme Court back in October 2011. The Michigan Supreme Court still has not decided whether they're going to take this case or not. Basically, they're illegal in Michigan. They're against the law. I can't answer that. Can't answer that, and I won't answer that. Because dispensaries, I'll emphasize it again, dispensaries are illegal in the state of Michigan. Can an employer discipline, terminate an employee for using medical marijuana? I mentioned that language that Section 4 says you can't be disciplined, so forth. Here's the case that's an important case. Cassius versus Walmart. The United States District Court ruled, this is Mr. Cassius. He was the employee of the month for 6 months in a row. He had cancer. He had a medical marijuana card. He tested positive for marijuana, which he used while off duty. The United States District Court in Grand Rapids ruled that the state's medical marijuana law protects users from arrest, but not employers' policies that ban the use of the drug. So Mr. Cassius loses in this case. He has appealed this case to the Sixth Circuit Court of Appeals. Because of time, I gotta skip some of this. I apologize. My PowerPoint is certainly available for you. What about an individual who's on probation or parole? We've had 2 county circuit courts recently rule that probation or defendants are not allowed the use of medical marijuana while on probation. Skip future concerns. When I gave this presentation 3.5, 4 years ago, I had up there future concerns. I now have concerns. I've switched it. And these are all concerns, as you can clearly see. I didn't even address children's daycare centers, federal subsidized housing, colleges, universities, so forth. Grand Rapids Press says fix the law. In order for the legislature to fix the law, right now there's 22 bills. In order for them to do it, you need 3/4 of both houses to amend the act. They have a very difficult time getting along pretty much on anything. This, to me, I want you to write this case down. This is a huge case. To me, this may be the most important case that comes down in the future. It's called Lott versus the City of Livonia. The City of Livonia passed an ordinance that basically said if you want to do business in the City of Livonia, you can't violate municipal, state, or federal law. Well, obviously, if you wanted to do some sort of business in the City of Livonia that involved marijuana, what law would you be breaking? Federal law. This is the pecking order. I'm telling you, this is the pecking order. The Lotts sued the City of Livonia and their ordinance. And here's what the judge said out of Wayne County, Judge Baxter. She said this: Livonia's ordinance, remember Section 7 of the E, if your law conflicts with my law trumps your law. Well, here's what the judge said. Livonia's ordinance directly conflicts with and is preempted by the Michigan Medical Marijuana Act, which regulates the use, distribution, and maintenance of medical marijuana and occupies the field of regulation. However, who has the ace of spades? The feds. The Medical Marijuana Act is also preempted by the Controlled Substance Act, which completely bans the use of marijuana and bans its use by physicians for a medical purpose. This case is in the Michigan Court of Appeals. This could basically blow up this act, depending on how it's decided by the Michigan Court of Appeals. And I'm not trying to be too dramatic, I'm just telling you, that's what could happen. Here's a crash in Livingston County. 18-year-old crosses the center line at around 90 miles an hour, hits this van head on. 5 individuals die, including the 2 in this van in their 60s, married couple over 40 years. And all the individual and the other vehicle had in the system was THC. I get really bothered when they say that THC, it has no effect on your ability to operate a motor vehicle in a normal manner. I always show them this picture. There's 2.5 ounces of marijuana, not usable marijuana, because you can see some of the seeds, stalks in there. And they don't like Bill Schuette, the medical marijuana advocates. As you can see there, this was a rally last September. 1,500 individuals attended. You see sunglasses, sunglasses, and sunglasses. So obviously, glaucoma is an issue. Sorry. And this is how you get a hold of me if you have any questions, or if you need any, if you would like my PowerPoint, I'll be glad to make sure you get it. I'll leave that up there for a second. I'm sorry I had to go so quickly through this, but once again, I want to thank obviously I want to thank obviously you, and I want to thank everybody. I'm truly humbled and privileged to be here.